So I said after finance, legal always has to follow. But this is very interesting because I think if one was to make a cloud of the words that have been used today, the word digital would have the biggest cloud. Effectively, if you look at the Indian law, most of the laws that have happened over the last 3-4 years, most of the laws that have been changed over the last 3-4 years, have one significant word involved with them. It is the word digital. Without going into a lot of details, I'll sort of skip a few of these things and then come to what may interest the audience the most. One is with respect to the personal data law that is proposed to come out. Second is what are the laws around AI and what are the best do's and don'ts for people sort of in the MSME sector. Again, I think the presentation is there. I'd rather not follow it. It's more of a free-flowing session. The personal data is called the Digital Personal Data Protection Act. That has been part of the statute book. It has been implemented by the parliament. It has been enacted in the year 2023, but it is not in effect yet. There are rules that have to be followed under it, that have to be prescribed under it. Those rules were under public consultation till earlier this year. That consultation process is over. We are sort of expecting the government to implement the rules sometime later in the year, after which the new law becomes effective. Was there no personal data protection law before this? The answer is no. There is an existing law under the IT Act, which is called the Sensitive Personal Data and Reasonable Security Practices Rules of 2011. Those rules, if you go to any website today, you will see a privacy policy. You click on it, you will get the rules. They effectively say, by coming to this website, you have consented to the privacy policy and we can do anything with your personal data. Thank you very much. And sort of move on. Everybody sort of has these policies. I have seen multiple FMCG companies have healthcare privacy policies pasted. The implementation is fairly lax. The new law, however, is going to be fundamentally different from how we look at personal data today as against how we will see it happening later. First of all, I'm a very big fan of the law. I think along with the schedules and the rules, it comes down to 30 odd pages. The law is one of those new age laws in India that has a lot of illustrations, which makes it very clear. I think there's a concerted effort towards making this law friendly for the individuals whose data is in question, rather than for the lawyers. It's again a principle-based law, like I was stating earlier in the morning. It is not prescriptive. It basically says this is how you should do it. How you do it depends on you, depends on the sector that you are in, depends basically on the size and scale that the business is at. And I'll tell you how sort of that law prescribes that. What does it not apply to? Manual processing. I don't think there is anyone in India who does manual processing, because when they had put manual processing in, someone asked a question during consultation process. They said, if you've taken it in writing and if you scan it, that is also digital data. So basically any personal data that you sort of process today will be in digitized form, and this law will cover it. What this law doesn't cover is foreign data being processed in India. That is applicable for GCCs who basically set up capacity centers in India. This law is not applicable to them. This law is applicable to personal data of Indian nationals, whether being processed in India or outside India. Unlike the earlier law, and unlike some reading that you may have done across the world, which have different categories of personal data, the Indian law, for a very specific reason, decided to not have separate categorizations. There is only one singular definition. Anything in relation to the person or by which the person can be identified is personal data. So my name will get the same sort of protection that my health information will have, right? Which is not true in many other geographies like Europe, right? My health data gets a higher level of protection, personal data doesn't. The logic that the government had was, I don't want to have multiple sort of implementation processes, I don't want multiple rules for it. Effectively, you have one process to follow for personal data. It's just easier for companies. Debatable, not debatable, again, depends on your perspective there. Domestic purposes, again, I think we'll sort of skip that. What is personal data? We covered processing. This becomes very important because even storage is processing, which a lot of people sort of don't understand. And I'll sort of give an example here so that people appreciate it. A lot of times one would say that I have not kept it in my active repository, it's there, right? People ask me not to use my data to send marketing communication. Okay, I kept it in some other server, which is not the active server. I am not processing it. That is actually inaccurate. Even storage is processing under law. You will have who's the data principal, the person obviously to who the data relates to. Data fiduciary is the person who sort of collected it. Data processor is the one who's processing on behalf of the fiduciary. I will spend a minute on the distinction between these two because it becomes very important, especially for people in the B2B business, because you would always want to be a processor and not a fiduciary. I always give the example of how you would get into a cab, right? If you get into a cab and say, I want to go from place X to place Y, please take me by whatever means you want, how fast you want, you are the driver, you are the boss, take it that way, that person is the fiduciary. If I get into a cab and say, this is the map, please follow it, go by this speed, go by this route, you will park it here, you will drop me at this place, you are the processor. Right? The driver becomes the processor there. So effectively, if I determine what is to be collected and how it is to be processed, I am the fiduciary. If I just process on behalf of the fiduciary, I am the processor. What is the benefit of being a processor for a B2B company? The law does not have any obligation on a processor. The only obligations under this law are on fiduciaries, people who collect it, people who determine what processing is to be done. So effectively, if you're a B2C company, fiduciary definition, but if you're a B2B company, it's actually easier for you to be a processor. But are there advantages to being a processor? Maybe not, especially depending on how you're using the data, right? And then sort of think along with the definitions, we will come to the use cases just so that people appreciate it here. A fiduciary can determine processing. So if the fiduciary has done whatever it is required to be done under the law, it can use the data in the way it chooses to process. A processor, however, can only process it in the manner that the fiduciary has determined the processor to do. Effectively, I cannot do anything beyond what has been told, right? And I will need to purge the data. So today, if you're a B2B business and you want to use the data for, say, training your own internal data sets, if that is not a part of your contract, if that is not something that is permitted by the fiduciary, you will not be able to use the data to train your own internal models, right? What is the way to get around it? Is the name of this act. It is the Digital Personal Data Protection Act. If it is not personal data, it is not covered under this act. What is not personal data? Anything that cannot be used to identify the person either on its own or in combination with something else you have, right? And therefore, so people who sort of are in the healthcare industry, US has a standard called HIPAA, which is basically in relation to healthcare data. They have 18 markers for healthcare data. So if those 18 markers are taken out, that data set is considered to be non-personal data, which can be used for anything. Do you have anonymization standards in India? No, we don't have anonymization standards. We've asked the government decided not to implement or give a bright line test around anonymization. Everybody who's sort of a computer geek knows that there is nothing called anonymization. If you have enough computing power, you can backtrack, right? There is no perfect anonymization anywhere in the world. But what are the standards you use? You look at it internationally now. So the government effectively has said the principle is you should not be able to identify this person. What is the process you have used? You demonstrate to me that you have used a good enough process. You don't have any other data set. And therefore, if you're processing that data, that is non-personal data, not covered under this act, right? Going back to what obligations of a fiduciary will be. If you're a fiduciary, and I'm going to sort of make it very simple, so not following the PPT because it's much easier to follow the spoken word. If you're a fiduciary today, you will need something called a consent notice. The consent notice under law has to be clear, simple, itemized. It does not have to be granular. I will tell you the difference. It will set out all the personal data that you are collecting. It will set out all the processing activities that you intend. It will also set out the rights that this data principal will have, which includes right to modify, includes right to withdraw the consent for processing, or to delete their data, or to seek details of who all are the processes involved in this entire journey. I will give the notice. I will need an affirmative action that needs to be audit logged by the company, right? Because this is sort of a digital first law, you would want to have it in an electronic format. The audit log has to be maintained. There has to be an affirmative action that is done by the data principal. On the basis of that, processing will happen, right? So today the question will be, what about my past data, right? Past data that I've collected, maybe not the same process, but I've collected past data. The law tells you that if you have collected past data based on consent, if you have taken valid consent of the individual at the time of collection, you can keep processing it till that person says, don't process my data anymore. So it is an opt-out mechanism, to sort of use the legal term, is an opt-out mechanism rather than an opt-in mechanism. So the day on which the new law comes, organizations have to be completely aware of what consent they have taken, what are the processing activities that are being carried out using this personal data. Have they gotten requests for withdrawal? Have they gotten requests for deletion which has not been honored till now, kept in a non-active repository, and therefore have to assess their own compliance perspective. Again, just to sort of clear any myths, this does not only include B2C data, customer data. It includes data of your employees as well, right? There is going to be a significant sort of scrutiny at this as and when the law sort of comes in and gets ramped up, but do not sort of confuse that this is only in relation to customer data. Your employee data, vendor data, say authorized person of the vendor, that data that you have collected, all this gets covered under the new law. Now, for people who are concerned, you may have 18 months, you may have 6 months, or you may have 18 months. The government has refused to give a timeline around when it will be implemented, but they've said that they will give timelines for companies to adopt this. Again, we will start from the top again. We've covered the consent notice. The consent notice has been given. Processing activities can be done. Unlike Europe, where there are multiple legitimate uses other than consent for processing data, India is a consent first regime. That has its disadvantages. I mean, those are philosophical discussions. Disadvantages are there. But unfortunately, India is a consent first regime. There are very, very limited exceptions in relation to processing activities that you can do without consent. So effectively, your consent notices, therefore, have to be fairly robust for you to be able to process this data going forward. It's again a business disruption risk that you will face if the consent notices are not in a certain way. Most of you will not fall into the sort of higher category, but depending on the sector that you are in, you may actually fall in. There is something called a significant data fiduciary. Significant data fiduciary is someone who either processes a large volume of data that will be specified in the rules, or you're in a certain sector. Largely companies in the financial sector or the healthcare sector is going to fall under that. That effectively means that if you're a significant data fiduciary, there are significantly more obligations on the person, which includes a data impact assessment. There has to be an audit that has to be done. A data protection officer has to be employed full time and at a very senior level. Now the question is, will companies in this room fall into the sector? Maybe not, but depending on how the sector is classified under the rules, people in the fintech sector or the health tech sector may fall in. If you are a data fiduciary, remember, if you're a data fiduciary only, if you fall within the exception of the processor, you will only have contractual obligations that sort of kick in. Exceptions, not really. I mean, there are M&A exceptions, but these are all code based. This is the most important part. Cross-border data transfers. Under law, cross-border data transfers are permitted other than a blacklist. So earlier, the earlier iterations of the law, the gate was closed unless the gate is open. Now the gate is open unless it is specifically closed for certain countries. Now let's come to what you should be doing in terms of your activities as a processor. I will start with B2B companies first because it's a little easier. One, you need to know what processing activities you're doing. You need to know what processing activities you're doing outside your contracts. That you have to be extremely certain about. You also need to have a timeline. No one's sort of saying that you amend your contracts today, but you need to have a clear timeline that your fiduciary, who may be significantly higher or larger in terms of their heft in the market, may try to impose all the legal obligations they have down onto you under a contract and sort of try to take contractual comfort from the way you're processing it. Those need to be resisted by B2B companies. B2B companies need to have their own policies, own formulations, saying that, look, this is the standard that we are following. You have legal obligations under law. We are merely a processor. We are processing on your behalf. And therefore, this is the way in which you're going to process. Right? If you're a fiduciary, then it becomes even more tricky for you, because what you need to understand there is what is the kind of personal data that you've collected, what are the processing activities that you're using it for, who are the third parties you have given it to, who are the different departments within your organization who may otherwise have access to personal data. And I'll give you a small anecdote which sort of makes it complicated. There are HR departments that will have multiple data sets of CVs that have come over the last 5 years, which is retained, saying that, no, what, if we have a requirement, we will reach out through our Rolodex of these CVs. Now the question is, do you really want to retain that? That is toxic data. If your cybersecurity incident happens and this data happens to come in the public sort of forum, you will then have obligations with respect to going in front of the data protection board and telling why you kept this data. So the exercise itself, and what we call in sort of parlance there is data mapping exercise, becomes extremely critical. I think that's what a lot of companies that we've been advising have been doing. You're not required to be compliant today. The new law is not in force as yet. The rules are not out yet. The implementation timeline is not there yet. But what you need to know is, if I have a problem, I need to know the universe of the problem. Today is a situation where you need to go back and see what is the universe of the problem, what is the universe of data I have, where are the interconnects that this data has with third parties, where are the interconnects that this data has internally. Do I really need the data? I think what a lot of companies, especially MSMEs, need to understand is data is oil is an old sort of buzzword. Is it really good oil? Is it really high value oil or not? Then you will realize that you sort of hoarding data which is not really required. Right? Your systems are sort of drowning with the amount of information that you're keeping. So that's the first stage that you lead to. Second stage is, let me try and see what notices I can have. Those notices will be informed by large sort of e-commerce companies. They will be the first ones out of the gate in terms of creating these privacy notices that can be looked at, and those can be implemented. Remember, and this I don't want to tell people because it gets a little scary in most forums, is that this law, unlike the European law, is not, the fines are not a percentage of your revenue. The fines are absolute numbers. The maximum fine that can go under this law is 250 crores. That's a business shutting amount for a lot of companies in India. But then again, like I sort of trying to calm people that you can be hanged if you commit murder. Not every day are people hanged in India. So yes, there is a delta between 0 and 250 crores. Where you will sit in depends on what processes you have. It's always better to say that, look, I was trying. I may not be perfect, but I was trying. Right? And that's the most important aspect around how you would look at businesses, how you would look at any new law coming in. A lot has been spoken about the IT Act. In fact, I was making a joke in the morning that the IT Act does not have the word internet. The government of India is actually looking at actively changing the IT Act. A lot of you may have heard about the intermediary rules, which have been used for app ban, which have been used for a lot of things. The intermediary rules have been obviously like a Frankenstein monster. There have been parts bolted onto it almost every year. But now they've realized that they will have a new law in place. No timelines around the law. The telecom law again is very, very new, which is very interesting. May not be of much sort of relevance to this audience. But the IT Act, or the new avatar of the IT Act as and when it comes, will be of great relevance. The earlier minister had in fact called it the Digital India Act. Now that is sort of shelved. We don't know when the new act is going to come, but it is definitely going to come. For businesses, as far as the Data Protection Act is concerned, I'll sort of stop there in terms of the Data Protection Act. There is no need to be alarmed. There is a timeline between the when the law gets enacted and the implementation timeline. A lot of it can be learnt over a period of time. A lot of it is in relation to how well you know your data. And therefore, if you know the extent of your data set and the processing activities, the rest of it becomes much simpler. Right? If you don't and you wait for the last moment, then you realize that, look, multiple departments have multiple sort of things. I can tell you, people who have sales departments will not imagine the amount of personal data that your sales team may be having. Right? Where they've got the data, please don't ask the sales team. Right? So that's how they're doing it. On AI, look, there's no law in India. In fact, we were speaking about multiple sort of papers that have come out. I have been advising some fairly large companies around it in front of SEBI and in front of RBI. There are multiple committees that have come out. The government of India thought of regulating AI, then they said that, look, we're not going to regulate AI. In fact, I don't know if people's memory serves right. 2 years back, the Consumer Affairs Ministry had said that anybody who's using AI, please come and register your AI with us and tell us what is the source code. They don't understand how AI works, so they said, please come and give us your source code. Then that got pulled down in 48 hours. So there are sort of government agencies trying to look at it, but the concerted government effort is, I want AI to grow in India. Let me not regulate it. I will have a principles-based regulation. In fact, that is what we've been telling the RBI also. And FSI has been at the forefront of it. I think in many ways, if you look at it, SEBI's investment advisory regulations have only one sentence with respect to AI. If you are using AI, please put a disclaimer, and that is about it. Nothing more than that. RAs, same thing. Now they've obviously come up with the paper, but again, that paper very thankfully says that it will be principle based. Do what you want with sandboxes, with human intervention, etc., which everybody sort of spoken about. What a lot of people don't speak about is the interface of intellectual property with AI, which is where people need to be very, very careful. Intellectual property and data are your business killers, right? If the data, which is especially personal data, has not been taken properly, or non-personal data, which will then be AI or someone else, you have not seen the source from which you've taken that data to train, or you have otherwise not taken consent, you are opening yourself up for massive litigation as your business grows, right? May not be even when your business grows. There are many people who are sort of litigious now, who would send notices to AI companies basically saying, tell us how you've trained your data, have you used my data? We are actually seeing a situation, and without giving names, there's a great company that I was sort of looking at investments. We were advising a VC. That company was trying to democratize IIT entrance examination training for people in tier 2, tier 3 cities. So what they basically said is that, look, people in tier 2, tier 3 cities may not have access to the best of books, may not have access to best of teachers. So why don't we train our AI on a lot of books? There will be modules, there will be question answer sessions through this application of theirs. Once a week, there will be a human teacher who will come in and solve doubts. Great model, great everything. What they forgot was the fair use exception under the intellectual property does not extend to commercial. So the moment they start charging for this, they could not have scanned these books and come up with their model. That becomes extremely problematic for a lot of companies who don't look at intellectual property. I know intellectual property is not at the top of minds of a lot of people, but if you are looking at using AI for your businesses, you need to be very careful around it. For businesses that are not software first or AI first, but are more traditional but want to use technology as an enabler, again, be very careful around your contracts, because the law today does not know who to fix the blame on. Why are we talking about hallucinations? The reason why we're talking about hallucinations at a government level is, whose neck do I catch if something goes wrong, right? Do I catch the neck of the person who's developed the foundational model, or of the person who's using the process, or of the person who's implemented the process? So there's obviously a very nuanced sort of way to look at it. There is developer claims, there are agent claims, then there are service provider claims, and then there are regulated entity claims, which can sort of be triaged to. Now, effectively, when you are doing your contracts, you need to be very careful around the whole risk allocation liability. If someone's coming to you with a new age product and says, you know what, because you're using it, you should have thought best, buyer beware, you are liable for anything that goes wrong, that is not something that you should be accepting, right? Nor is it the other way around, that the person who's developed the AI is responsible for everything. That is also not the answer. The answer lies somewhere in the middle, and these are things that you should be considering if you're a traditional company sort of embracing new age technology to augment your businesses. I sort of stop it at that, take more questions, because yeah, I have advice on it. Huh?
What do you feel in case of Digitization? All information we are providing, you collect all data from
It does. See, the privacy policy of Digiyatra is very interesting, because I had the fortunate or unfortunate thing of drafting it. So the way Digiyatra sort of works is very interesting. There's a tech stack around it which effectively ensures that the way your data is retained, right, is retained in a manner that is privacy first, right? There are airport authorities who sort of come together. There is the AI at the top of it, and Digiyatra is maintained by a third party. Is a app developed by a third party, sort of maintains it. If I remember correctly, it's a non-profit government, not government entity, non-profit entity, where the airport sort of operators have certain stake and the AI has certain stake. So that is the entity that is sort of operating and controlling Digiyatra, right? How it does it technically, we can sort of do it aside. Yeah.
For a lot of websites and digital products, there's always this terms, there's a long list where we say agreed. So practically, from your experience, to what extent does it absolve the product owner in case there is a wrongdoing on the other side? Simple example being age limitation. Let's say app which is distributing, let's say, alcohol, right? Till what extent can the liability come back to the owner? Because there could be multiple case owner, as in the product, the developer or whatever you call it, the startup founder.
Personal liability in India, if you're a private limited company, if I heard you right, if you're a private limited company, unless there is malified intention of fraud that you're trying to commit, personal liability in India is not there. There is something called a corporate veil. The corporate veil can't be lifted. That's an established law for about 200 years, starting in the UK. That if there is a company, until and unless you've created the company only for committing the fraud, it does not go back to you. Right? The reputational sort of things aside, right? With respect to the long terms and conditions, having only terms and conditions does not help anyone. You have to, tomorrow when there is a challenge, you have to always demonstrate that how these terms and conditions have been affected by technical measures. Saying that I don't allow minors, when you specifically have certain this thing and someone says I was born in the year 2012 and you start serving alcohol, it doesn't really help, right? Your sign up page doesn't talk to your terms and conditions page. So those are sort of blatant things. So your company obviously gets into trouble, not the founder.
Okay, I have a question here. So, would it hamper ease of doing business for community-driven companies?
The personal data law?
Yeah.
I would say the intermediaries guidelines have already made it difficult, right?
Right. So I want to follow because I'm a founder of a PaaS on SaaS kind of a company where my SaaS clients are service providers, and I have a couple of products where a consumer is coming on board, right? And I want to create that personalized experience for them, right? On multiple levels. So if I'm not storing their data or if I'm not storing their information, it kind of hampers the experience there.
You can see. I'll tell you where the apprehensions, the questions are coming from. The overhang is from Europe. Everybody's sort of heard about GDPR in Europe. Everybody's trying to correlate GDPR with this law. This law is very different. This law, I'll tell you, is very similar to the Singapore law. Okay, this law is not like GDPR. Effectively, if you have taken consent, you have disclosed a use case. Right. If you have disclosed a use case, then and taken proper consent, you can process it. Look, I keep telling my clients, will you never get a notice in life? That is impossible. There will be someone who will always be dissatisfied, someone who will say that you are using my data in a wrong way. Effectively, if you have taken consent in a proper way, there is a definite use case to the personal data, you can always defend it.
There's this company called Mine, if you're aware. Yes. So basically, I can go on Mine and see like where my digital footprint is.
Yes.
And so what would their impact be on a company like ours?
See, without going into details, again, the provenance of how they're getting it is in question. There are other laws which are there. So under the IT Act, I cannot go and crawl websites in an automated fashion. Right? There are enough cases around it. So I'll not go into the details of how they sort of get that information, but effectively the provenance of the information becomes very important. In the same way, there are enough people in India who say we are data brokers, right?
Okay, and final question, because of this law, what would the impact be on advertising or targeted marketing? Maybe on my personal platform or on something like an Instagram or a Facebook or WhatsApp tomorrow? I
wouldn't see, again, I think you're sort of going towards targeted advertising, if I'm not mistaken, right? Now, targeted advertising, I'll tell you, will become a little trickier, right? Because it's consent based, it depends on who's given consent, right? So your tech stack behind how you push that ad has to be very clear. So every time there has to be a call effectively saying, do I have consent to show? Do I have consent to process this, and then do I have a consent to show? Right? That becomes, and it's dynamic. It's a problem. And in fact, one of the things that they wanted to clamp down on was unfortunately targeted advertising, where effectively I could have given consent today, I can give consent tomorrow and withdraw consent day after and keep toggling, and then your server costs go up.
That is what actually they have done with TRAI regulations as well.
Yeah.
A big problem now.
Yeah.
Thank you.